Does training data impact AI content ownership rights? Imagine creating something new and wondering who actually owns it. When it comes to artificial intelligence, the answer isn't always straightforward. It all starts with the data used to train these smart machines. Training data can include copyrighted works, private information, or proprietary datasets. If the data used to teach the AI includes copyrighted material without permission, it can complicate who owns the output. Copyright law gives original creators exclusive rights to their work, including copying and making derivative works. When AI models are trained on copyrighted content, copying and storing that data might be considered infringement if done without proper licenses. If the AI produces content that closely resembles the training data, it could infringe on the original creator's rights. That means ownership of the AI-generated content can become a legal gray area. Getting the right licenses for training data is key. If a company has permission or licenses to use third-party data, they can often claim ownership of the AI output based on those agreements. But if they use data without authorization, disputes can arise over who owns what. Recent lawsuits highlight this issue. For example, cases involving Getty Images and Stability AI, or the New York Times, and OpenAI focus on whether using copyrighted images or articles without permission breaks copyright laws. These cases show how important licensing is for ownership rights. Some argue that using copyrighted works for AI training is similar to how humans learn, which might fall under fair use. But courts have not yet made a clear ruling on this. Fair use depends on factors like how much content is used and whether it impacts the original market. This uncertainty makes it harder to determine who owns the AI-generated content. Another factor is how the AI remembers training data. The model's internal settings, called weights, can encode parts of copyrighted material. If these weights contain copyrighted content, the AI's outputs might also infringe on those rights. Plus, if training data includes personal information, privacy laws like the General Data Protection Regulation or the California Consumer Privacy Act can limit how that data is used, affecting ownership rights. Companies often use contracts to clarify who owns what. They specify whether the input data or the AI-generated content belongs to the developer or the user. If the training data is in the public domain or properly licensed, ownership of the AI content usually belongs to the developer or user, depending on the agreement. In the end, the ownership of AI-generated content depends heavily on the legal status of the training data. If the data is owned or licensed by someone else, their rights can influence who owns the output. If the data is open source or public domain, the developer or user typically owns the content. So, training data ownership and licensing are fundamental in determining who holds rights over AI creations.